Karen Reed files an appeal saying she should have been acquitted on second degree.
But is that even going to make a difference? Karen Reed's defense team filed for appeal. But is it really going to change anything? I'm Lainey Law.
And I'm attorney Andrew Myers. How can you be so cynical?
Oh my goodness. On this channel, we talk day after day on cases where it really just feels like the defense team is just throwing everything they have at the wall and, it doesn't really seem to make a difference. I don't know. I can't imagine this appeal being any different.
Well, I think you're being too cynical about it. I mean, we're going to get to it in a second, but they went through a 2.5-month trial that started in the middle of April, wasn't even done until the week of the 4th of July. 74 witnesses, over 600 exhibits. And then after the mistrial, a bunch of jurors, 6 of them come out and say, we would have acquitted her on the second-degree murder charge and one other count. And so, yeah, I mean, if you're in her shoes, of course you're going to appeal. Of course you're going to appeal. Why wouldn't you?
Well, and especially because, as if you've been on this channel before, you may remember that we've talked so much about how long the jury deliberations took and how they kept coming back and forth until eventually they settled on that note where, like you mentioned with the 6 jurors, that all of a sudden all of these people are coming out of the woodworks being like, well, we had an agreement. So it makes sense. It makes sense for the defense to do this. I'm not saying that it's not logical, but is it going to do anything?
Well, let's see. They made some good arguments. And so here is the appeal right here. Karen Reed petitioner versus the Commonwealth of Massachusetts. There's a new attorney, by the way, Michael Pabian. He is apparently a partner of Martin Weinberg. They're both of Boston, but there's Alan Jackson and David Yannetti. And, you file an appeal brief and you've got to cite law and tell the court what you're basing it on. So it starts right here. Now comes the defendant, Karen Reed, aggrieved by an August 23rd, 2024 memorandum of decision and order denying her motion to dismiss on double jeopardy grounds. The order as it currently stands will result in Ms. Reed being retried on January 27th of 2025 for the same 2 alleged crimes, including second-degree M, that a jury of her peers has already unanimously agreed the Commonwealth failed to prove beyond a reasonable doubt following the trial. So they go on, they specify all the things that are being filed along with this brief. It's a lot of work going to the Supreme Judicial Court. So you better bet that, there was good reason to do it. Look at all those attachments to the appeal papers. And the appeal papers are 37 pages.
Yeah, I will say ultimately to go to the Supreme Court. There's no other solution. The defense team is doing everything correct, in my opinion, by trying to do this. But you really got to have all your ducks in a row, too, when you're doing something like this. So.
And this is significant maybe for non-legal eyes. It doesn't make a difference, but they've actually put in a request for an oral argument. So, the Supreme Judicial Court can, in fact, and I am a Massachusetts attorney, they can, in fact, just decide a case on the papers. But as long as you put in a request for an oral argument, 99 times out of 100, you're going to get. So I think that most of our viewers and commenters know most of the background. So we're going to skip most of the background. This is important here, though. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all of its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. And they cite U.S. Supreme Court law. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial.
I think that makes a great point with the increases financial burden. It's just like, well, it's not even just increasing the financial burden on the defendant. I mean, obviously, if sorry, in the state's point of view, they have unlimited money, but it's just like you're also wasting taxpayers' money. It's just like, I don't know. I mean,
Absolutely. Now, you had pointed out that there were notes from the jury. The blue writing in the margin, that's my writing. I made some notes here. There were 3 notes from the jury. There's note 1, there's note 2, and we've gone into these extensively in previous episodes, so we don't have to go into them here. Note 3 was the one that really stood out in people's minds. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. And here's the sentence that made a lot of us scratch our heads. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. And after reading that note, and without soliciting the views of counsel in any respect, the trial court stated, I'm not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case. So the interpretation of exactly what happened there, to a large extent, I think, is the basis for the appeal.
mm-hmm.
So again, I think our regular viewers, our regular viewers know the background. So we'll skip over that. You can go to one of our previous episodes. But they come right out and allege 2 mistakes that they say the court made. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designed to encourage a verdict, with consent to a mistrial. So they're saying the court confused those 2 things in the court's order. Finally, the court rejected the defense's alternative request for a post-trial inquiry on these issues on the grounds that the request implicated the substance of jury deliberations. So those are the 2 errors that they say the court made. They start here with their legal arguments. So here's where the argument starts. And based on all of the facts of the case, the attorneys appealing Karen Reed's mistrial and the fact that the court refused to allow the jurors to come in, what constitutes an acquittal is not to be controlled by the form of the action in question. And they cite U.S. Supreme Court law. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Because remember, the court said, we don't care what the jury might have said later on in affidavits, or 5 or 6 of them calling the attorneys. The only thing that counts as an actual verdict is a verdict that's read in open court. Well, here, the attorneys are saying, no. I mean, it's very clear that they came to a unanimous verdict on 2 counts, including the second degree M. And let's not just go back to form. I mean, what's more important is what they're arguing. Is it important that the thing be procedurally and formally, followed to a T? Or is it important that after 2.5 months of evidence that Karen Reed was found not guilty on on 2 of the counts, and yet they weren't given the opportunity, they argue, to say that?
Now, I have a question.
Yeah.
Because so they're saying that 6 jury members have come out and said this. From everybody else's perspective, we have no way of knowing if that's true or false, and there's 6 other jurors who could be thinking other stuff. Now, because they're sending this appeal, if the appeal goes through, they're going to have to identify, they're going to have everybody come back and say that they agreed on that, right?
Well, let's jump to the bottom and see what the attorneys are actually looking for, because in anything like this, You have to make a prayer to the court. We usually think of prayers as going to church. No. when you file a motion or an appeal or a petition, you've got to tell the court what you want them to do. So here's what they want to do. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court reverse the trial court and order that counts 1 and 3 must be dismissed.
That's a big ask.
They're actually looking for counts 1 and 3 to be dismissed. So the attorneys in this appeal point out that it would not have been unusual, which is what they were asking the Superior Court to do, to actually bring the jurors back. They talk about the Tsarnaev case, where there were questions of biased jurors. And then a more recent high-profile case, and another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alex Murdoch that during his murder trial, the clerk of court improperly influenced deliberating jurors. See State versus Murdoch. Order attached here too is Exhibit A. Jurors came forward after the clerk published a book about the trial describing her efforts to obtain a guilty verdict through improper jury tampering. And they point out that the clerk allegedly told jurors after the defense began its case, quote, not to let the defense throw you all off or distract you or mislead you, and warned them not to be fooled by Mr. Murdoch's testimony in his own defense. The trial court held an evidentiary hearing on the motion for new trial, including testimony by jurors. And as in the Tsarnaev case, the issue was not racial bias, but nonetheless implicated fundamental constitutional rights like Ms. Reed's right not to be retried for offenses which she has already been acquitted. So that was very unusual. I remember the Murdoch trial. I remember people saying, well, they should bring the jurors back. And a lot of us thought, well, you know what, that's pretty unusual. That's really kind of an unusual thing. That's kind of a stretch. But they did it. And they brought back a retired South Carolina judge who conducted a very limited inquiry of those jurors, but they did bring all the jurors back. And she questioned them, pointed questions, went through. There were questions about whether that was the right thing to do. But what they're saying here is that there is precedent for all of that.
Mm-hmm. It's interesting, too, because it's just the fact that we're seeing citation of a case that's recent enough that we've done. I mean, we've joked about in the past how some of the cases that they're citing are start with the 1900s, some even, I think there was one, I forget which one it was, but we did one case where we discussed one of the examples being from the 1800s. So it's cool seeing the Murdoch case come up, where I'm assuming that a lot of people watching this are familiar with that trial. But this is like what we've been saying the whole time with the Karen Reed trial, where is it like the effort between making a few phone calls or having a couple people come back into court versus retrying this whole court case again? If you want to retry one of them, fine, go retry one of them. But I feel like this should, in an age where we have so much technology readily accessible, this shouldn't be this hard, I feel.
Yeah, not only that, but just the whole matter of now having to go through this appeal process. It's not an easy process. I've been through it. I've been to the SJC and the Massachusetts Court of Appeals. Not often, but I have been there. And it's a lengthy, difficult process. The appeal was originally made to a single justice of the SJC, but very quickly it was bumped to the full court panel. And there will be oral arguments. The Commonwealth will be given an opportunity to brief it. It's a lot of work. It's a lot of work. And you can imagine the amount of time that goes into the research and then the oral arguments. And then the Supreme Judicial Court has to sit there and write out a decision. So, I mean, in one sense, the whole thing could have been avoided if Mass Criminal Rule 29 had been observed, where the court could have questioned the jury after 2.5 months of trial. Okay, let's break this down into the 3 counts. Were you unanimous on count 1, count 2, count 3? That didn't happen. Or the other alternative certainly would have been to bring them back. And as you point out with technology, why not do it on Zoom or court call? The courts, the courts have their own, different courts have their own proprietary systems, but they're like Zoom or a StreamYard for people that are familiar with that. So in any event, You know how I always say sometimes the interesting stuff is in the footnotes. Look at this. Turtle Boy made it into the Supreme Judicial Court.
Oh my
Look at this.
God.
Look at this footnote. Footnote number 1. Just days ago, an article was published online reflecting an interview with an anonymous juror quoted as saying, "It was very clear on charge 1 and 3. M was decided on day 1. She did not have an intent to M. Aidan Kearney," for those of you who don't know, and I think you all do, that's Turtle Boy. And they're citing Aidan Kearney, Canton cover-up, part 397. Karen Reed, juror, says they switched on manslaughter verdict. Confirms murder acquittal. Says jurors could not ask Judge Cannone questions about 2 verdicts. Available at, and there's the citation if you want to look it up. So there he's in the footnotes of this case. So
I'm just so curious because I feel if it was so clear that they came to a consensus on charges 1 and 3, then the whole juror note confuses me, because if that was the case, then it seems as if it was almost maliciously omitted. But then if it was maliciously omitted, then it wouldn't have been unanimous on 1 and 3. So I don't understand that. I don't understand how it got to this point in the first place.
Well,
if it was actually like unanimous.
You know, I'm not the biggest football fan. As all of my friends will tell you, I will watch if the Patriots are in the playoffs. Back in the Tom Brady days. But, you know, it's easy to look back and Monday morning quarterback this case, but it does seem that the options I talked about earlier could have avoided all this. But let's take another look at some of the highlights of this appeal. And neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such final unanimous agreement was not announced in open court. So now remember that, and we know what the prosecution's going to say because they've already argued these things in their motions in the Superior Court. They're going to say that the only verdict that is a valid legitimate verdict is one that is read in open court by the foreman in front of the judge, and then the judge enters it formally. That's what they're going to say. But in this appeal, they're saying, no, neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such final unanimous agreement was not announced in court. So what they're saying is, the whole basis of the trial court's ruling is erroneous. And they cite a brief that says that counsel arguing that Commonwealth had not cited a single case with facts like this that have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of a demonstration that we were silent when we shouldn't be, but she was acquitted. So this case squarely presents that issue, and the defense respectfully submits that this court, the SJC, should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This issue is one of existential importance, not merely to Ms. Reed, but to the very foundation of the constitutional safeguards that protect her. That's strong language. Strong language. I mean, we spend a lot of time in law school and in court observing the rules, observing the formalities, observing the technicalities. And as attorneys, yeah, we're expected to follow all that. But what they're saying here is a basic fundamental constitutional right kind of overrides all of that. If you look at the rule books, in most rule books, rule number 1 or a preamble says these rules can be overlooked for good cause shown. And I think that's what they're saying here. This is certainly a good cause.
I feel like there's no reason not to at the end of the day. I think, like I mentioned before, it doesn't make sense that with all the advancements we have, that this can't be something that sorted out. I think that using the Murdoch case was an excellent example of how quickly this could be resolved. Do I think that it's going to be quickly resolved? I don't know. See, the fact that it's now leaving Massachusetts gives me a little bit of hope, but I'm still feeling a little bit pessimistic about this. I just it it's interesting. I like think about just the way, obviously we've been doing court, the way we've been doing it hundreds of years, and it seems horribly inefficient to me.
Well, I think I pointed out before, I was talking to a trial attorney friend of mine who tries a ton of cases, and he said resolving disputes by a trial is a horribly inefficient way to do it. But, how else do you do it? I mean, the Commonwealth wants to go after Karen Read, and Karen Read and her many followers feel she's innocent. So how else do you do it? The other issue in this is manifest necessity. There should not have been a mistrial without a proof of manifest necessity. And here they're saying, importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. It should have been the Commonwealth proving that. They cite some cases, and this burden remains solely upon the Commonwealth, regardless of whether or not a defendant objects to the declaration of a mistrial. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving that final jury note, the one that we just read, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Now, the way the court got around that, remember in their brief, the court said, well, in this 2.5 month long trial, I've never known the defendant's attorney to be shrinking violence.
I was going to say that she was probably really pissed when she read that. If she read that, I don't know if she's reading these.
Well, of course she's going to read it.
Oh,
you know
think
she's read it already. You know that she has read this, and she's scratching her head because she's not a party to this. I mean, she's the central focus of this, but Judge Cannone is not a party to all of this.
My God.
And the Supreme Judicial Court is an appellate court, which means they determine issues of law based on the facts that are submitted. They don't hold evidentiary hearings. And so, barring some unusual circumstances. So here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. We have the video of the court after the notice was read. The trial judge said that she was not going to put the jury through that. Camera panned over, and that was it. That was it. So they go on to point out that the defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of Mass Rule of Criminal Procedure 27B, request that the jury be polled or discuss the issue with Ms. Reed. The defense respectfully submits that, given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. And they cite some law. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which she was deadlocked.
Yeah.
The option is apparent from the face of Mass Rule Criminal Procedure 27B, which states that the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict. So the problem is, and the court's going to say, or the Commonwealth's going to say, that word may. The judge may declare a mistrial because you know what? It doesn't say that the judge must or has to.
Mhm.
It says the judge may. So that's
Yeah.
the problem with that argument.
Yeah. I still this I'm still caught up on, like you mentioned, the idea of Judge Cannone reading this, and it's just like the back and forth, the shrinking violets, that she didn't give us an opportunity and now is basically going to their boss. It's the equivalent of CCing someone's boss to the email when you're not getting along with someone. So, I mean, I don't know. I don't know.
I don't know either. That's gonna be a problem. And their answer to all this, the defense's answers to all of this is that notably the trial judge. See, I always say that the real important stuff is down in the footnotes. I don't know why people hide stuff down in the footnotes, but they do. I'm probably guilty of it too. But footnote number 5, notably the trial judge did ensure that Ms. Reed was personally consulted regarding less weighty matters. For example, on May 24th of 2024, the court called Ms. Reed to sidebar and personally asked her to verbally consent to Attorney Jackson's absence on the Tuesday following Memorial Day, and that co-counsel Attorney Yannetti could represent her on that day. So they're saying, there is precedent for stopping the thing, which she could have done after that note was read and before a mistrial was just immediately granted. They're saying there's precedent for the court to say, okay, and how much time does it really take to say, okay, let's just stop a second. We've been here for 2.5 months since there was snow on the ground almost. Let's just stop, think, talk. Do you guys want me to grant a mistrial? So that's what they're saying.
I guess my question too, though, is what is the defense is arguing that they didn't have an opportunity to speak, but also what is the speaking option? I mean, are also saying they didn't get to consult with Karen Reed, but are they gonna, like, was the expectation that they say, oh, it's a mistrial and you scream objection? Like, I don't even.
Well, I think the objection is this. I mean, the jury came back, read that note. It would be a terrible thing for us to have to do this, and the judge said, "I'm not going to do that to you. I'm granting a mistrial." What they're saying is the thing should have been stopped, and she should have looked up to Yannetti and Jackson and Reed and said, "Okay, do you have any objection to my entering a mistrial at this point? Do you guys have anything to say?" And they would have at that point had the opportunity to say, well, Your Honor, under Rule 27, there were 3 charges, and they're just saying they can't arrive at a verdict. We've been here all this time. There have been 74 witnesses. Why don't we poll the jury on counts 1, 2? I mean, we spent days literally arguing over the jury verdict form. It was changed. The second count was changed to have lesser included offenses. So in that we took all that time to have a special jury verdict form spelling out all 3 counts and count 2 having alternatives, why don't we just stop and ask the jury what they felt or how their deliberations went on all of the counts. That's what they're saying. They're saying that they weren't given the chance. Here's a sentence that's really pertinent here. In these circumstances, the Commonwealth was unable to satisfy its heavy burden of proving that there was a manifest necessity for declaring a mistrial. The defense respectfully submits that the same result is required here. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity, even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial court could not continue with fewer than 6 jurors. So, they go on, and it's a little bit repetitive. And if you have any questions, bring them to us down in the comment section. We're happy to answer questions. And I do promise you that even though this episode is really focused on the defense's position, when the state comes forward with theirs, we'll give them equal time. We will go over their arguments. There might be something new from the time that they objected in Superior Court, But we already looked at this on your question earlier, but let's just look at the conclusion. It is uncontroverted. The defendants say that according to the jury of her peers following trial, Ms. Reed was unanimously found not guilty of counts 1 and 3. That undisputed fact must not be lost in this analysis. It bears repeating that at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potential instrument of oppression. Conclusion: for the following reasons, Ms. Reed respectfully requests that this honorable court reverse the trial court and order that counts 1 and 3 must be dismissed. So that's it. I don't know. I don't know. I went off on a little sidetrack earlier saying that, the defense is arguing that it's, let's not, get ourselves involved in these little rabbit holes of procedure and technicalities. Let's look at the big picture. If in fact the jury was unanimous on counts 1 and 3, that rises to fundamental basic constitutional proportions. But when you go to an appellate court, technicalities and procedure are pretty much, they rule the day. I mean, for example, even the font size and style and the size of the margins and the number of pages, all of those things must be observed or they're going to bounce your petition out. So where you're going to a court saying, technicalities,
may.
And that court itself, has a very, very, very high standard for observing technicalities and rules and procedures. I don't know. I really don't know.
I don't know. I feel like, there's so much that happens, and it's, as an ordinary everyday citizen who will hopefully never find themselves anywhere near this situation, this whole thing is beyond incomprehensible to me. The whole fact that they need to fight and to fight and to fight just to get the jury's opinions. I am really shocked that the juries can go home for the night. And yeah, they're concerned that, well, now at this point, so much time has passed, so maybe something would have happened. But if they had just checked in with the juries earlier.
Well, these are the things that happened, and let us know down in the comments your view. What's going to happen? Do you think that the Supreme Judicial Court will allow this petition and dismiss counts 1 and 3? Or do you think the Supreme Judicial Court will go through the procedure and say, nuh-uh, and the case will be retrialed? The second trial at this time is scheduled for January 27th. That's a pretty tight schedule for going to the Supreme Judicial Court, where, the other side is going to be allowed, I believe it's 30 days to write their brief. Then the court is given time, and usually you don't get arguments for a number of months. It could be a number of months until you get that little notice electronically now that, dear attorneys Unetti and Jackson and the other 2 attorneys that are now in the case, your oral argument will be such and such a date and time. And that takes time. And then you have your oral arguments, and then it takes time for the court to sit down and discuss it and issue a ruling. So the real question procedurally is whether they're going to get all that stuff done. Because, I mean, let's face it, right now as we record this, summer is pretty much in the rearview mirror. I hate to say it.
No.
We're looking into the barrel of the holidays. Yeah, people are putting up their Halloween decorations, not me. And so the holidays are coming, and whether they can get through all of this before then, I think it's questionable. But, maybe they'll speed it up. I mean, the interlocutory appeal in the Koberger case was slam, bam. So we'll see. Okay.
Yeah, I mean, like you said, we're coming up on the holiday season. January is right around the corner. So thank you guys for watching, and we look forward to seeing you in the next one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.